Hi everyone, this is Attorney Lilian Chukura with Lily Legal, and we help our clients get immigration status for themselves and for their families using the U.S. immigration law system. So today, I want to talk to you about how a child can get citizenship through their parent or parents. Okay, how a child can get citizenship through their US citizen parent or parents. Okay, so that is what we're going to be talking about today. I hope you are ready to jump into this topic with me. Okay, so if you have any questions about this or anything else, you can book a time to talk to me confidentially in person or by Zoom by going to my website, lilylegal.com, or by calling my office at 508-443-1788. So, I know I always tell you all to put your questions in the comments, even if you're watching this on the replay, because it might be the it might lead to me making a whole video based on your question. Well, that's what today is all about. I received a question on one of my videos, the step parent, step child video, and the question was about getting citizenship through a step parent or step child. I answered the question there, but I also wanted to really talk to you all about this topic because a lot of people don't know that you can actually acquire, derive citizenship from your US citizen parents, even if you're not born in the US. Okay. So I want to go through that with you today, how that works, what the requirements are, all of it. We're going to go over it. And if you have any questions, right? If you have any questions, put them in the comments. If you are watching this on the replay, go ahead and put your questions in the comments. Like I always say, it might end up being the topic of a live, which is what's happening today. So feel free to ask me your questions. So, first off, I will go ahead and answer the question that led to this video, which is, can a step parent give citizenship to their stepchild? Right? There's a form called the N600. Can a stepchild file that based on the stepchild step parent relationship? Unfortunately, the answer to that is no. In order to derive citizenship from a parent, that parent has to either be your biological parent or your adoptive parent. Okay, so you have to be related either biologically or by adoption. Those are the rules. Unfortunately, step parent stepchild relationship does not lead to automatic acquisition of citizenship. But that does not mean that you can get your green card through your step parent and then in 5 years apply for citizenship. Okay, so that's really the difference there. Is instead of automatically becoming a citizen, you will just have to wait the amount of time, which is typically 5 years, in order for you to be able to then apply for citizenship. Now, for other people that are either related through birth or adoption, right? Everything I'm going to go over today is going to apply to you. So stay tuned. And like I said before, if you have questions, go ahead and ask. This is going to be a lot of information. And if you want me to do a more detailed video on just parts of it, I am glad to do that as always. So I hope you get a lot out of this. So, the first thing you need to know is, like I said, has to be either your birth parent or your adoptive parent. Then the next question is, are both parents US citizen or is only one parent a US citizen? So the rules are different depending on the answer to that question. And then the next thing is, are the parents married at the time of birth? Okay. So one, are they both US citizen, or is it just one parent that's a US citizen? And were they married at the time of the birth, or were they not married? So children born in wedlock, which is the term that um, US immigration law uses. So children that are born in wedlock have different rules versus children that are not born in wedlock. So children that are born out of wedlock. We are going to start with children born in wedlock. And I'm going to, again, break it down by whether both parents are US citizen or just one parent is a US citizen. On a basic level, if you are born in the United States, okay, if you are born in the United States, you are a US citizen unless you fit into, unless your parents are diplomats, and there's different rules for that. But generally, if you're born in the US, you are considered a US citizen. Okay. Now let's go to if you're not born in the US. Okay. So that's the next thing. If you are born outside of the US and both your parents are both your parents are US citizens and they are married, right? We're starting with wedlock. Both parents are US citizens and the parents are married to each other at the time of the birth, and at least one parent lives in the United States at the time of the birth. Then you are automatically a US citizen at birth. Okay? So let me say that again. If your parents are married when you were born and both of them are US citizen and at least one of them was living in the United States at the time of your birth, you are considered automatically a US citizen at birth. Now, how do you actually go about proving that you're a US citizen? If you were born outside of the US, you can go, your parents, right, can file something called consular, basically register your birth abroad at the US consulate in whatever country you were born in. They will have to prove that both parents are US citizens, both at least one parent resided in the United States, and that they are married to each other. Okay. Once they're able to show that, then they can register your birth at the US Embassy, and that is your proof. It basically serves as a birth certificate. And now you are automatically a US citizen. You can get your passport, all of that. You have to fit this requirement in order to be able to do that. Now, if only one parent is a US citizen, then the rules are different depending on when you were born. Okay. So if you were born, let's say you had a child today, right? And you want to know if that child that is born where one parent is a US citizen, both parents, the parents are married to each other, but only one is a US citizen, and the child is born out of the United States. That's what we're talking about. Remember, if the child is born in the US, they are US citizens. So we're only talking about children born outside of the US or its territories. So if at least one parent is a US citizen and the US citizen parent has continuously resided physically in the US for at least 1 year, then the child is automatically a US citizen at birth. Now, if the child is born outside of the US on or after November 14, 1986, okay, November 14, 1986, to one US citizen parent and one non US citizen parent, the US citizen parent has to show that they have been physically present in the US for at least 5 years. Okay, so born on or after November 14, 1986, your US citizen parent has to show that they have been physically in the US for at least 5 years. 5 years. So that is really the rule there. So if both parents are married to each other and you were born on or after November 14, 1986, and one of your parents that's the US citizen can show that they have been physically present in the US for at least 5 years at the time of your birth, you will automatically have US citizenship. Okay, that 5 years has to be before you were born, not after. We'll get into what happens if it's after you were born. We'll get into all of that. But if it's before, then you fit into this category and you would automatically become a US citizen at the time of your birth. If you were born between 1952 and 1986, your parent has to show 10 years of physical presence. So that's the difference there. Okay. And the older you get, the rules are different. So make sure before you apply that you know when the person is born, and what rule applies to them. And I'm always happy to discuss that with you. Now, if the child was born out of wedlock, so we've been talking about children born in wedlock. Remember, if both parents are US citizens and at least one of them resided in the US at some point, then the child is considered automatically a US citizen. If only one parent is a US citizen, right, and the other parent is a US national, so that means they live in the US but they're not a citizen, the child will automatically get citizenship if if the US citizen parent has lived in the US for at least 1 year. If one parent is a US citizen and the other has no nationality, is not a US national, has never been in the US and had the child outside of the US, the child can get citizenship if they were born on or after November 14, 1986, and the US citizen parent had resided in the US for 5 years. If they were born between 1952 and 1986, the parent has to show 10 years of physical presence. And trust me, I have used this for my older clients to show that they are US citizens. Without them having a green card, like we were able to prove that they were a citizen. So this can apply to people today trying to see if the child they had recently will be considered a US citizen. And this can also apply to an adult that wants to know if they are already a citizen and just don't know it. And that does happen. Okay. I always check in with my clients, and ask them a bunch of questions because, excuse me, and ask them a bunch of questions about their parents, because sometimes, depending on when their parent became a citizen, they may have automatically become citizens and didn't even know it. They were walking around the US thinking that they're not citizens, and they actually were. So that's the good thing there. Hi, Kimberly. So her question is, can they get dual citizenship in some cases? So yes, the U.S. allows people to have dual citizenship. So U.S. is not an issue when it comes to dual citizenships. There are certain countries that will only allow you to have one citizenship. So, for example, India does not allow dual citizenship. So most of my Indian clients have to choose between um, being a U.S. citizen and or an Indian citizen. So that choice has to be made in certain countries, and but for the majority of the countries, you can be a dual citizen without having to do anything extra. For example, me, I'm from Nigeria. I am a Nigerian citizen and a US citizen, and I don't have to do anything extra in order to have both citizenships. So it really depends on the country and if they allow dual citizenship. If they don't, then you have to pick. which country you really want to be a citizen of, and then the other country you'll either remain. If it's the US, you will remain if it's the US, you'll remain a permanent resident. If you choose not to become a US citizen, you'll just stay a permanent resident. If you choose to become a US citizen, then you might just need a visa to go to your home country. So that's just something to keep in mind there. But typically, US allows dual citizenship. Okay. So for children born out of wedlock, right? This is one of your parents were never married to each other. Your father is a US citizen and your mother is a foreign national. Okay. So here it really matters who is the US citizen. So for when your parents are married to each other and you were born in wedlock, it doesn't matter if your father is the US citizen or if your mother is the US citizen, the rules apply the same. However, if they are not married when you were born, the rules are different. I know it's not fair, but that's just how it works. So if the father is the US citizen, okay, and you were born outside of the United States on or after November 14, 1986, the child's father is also in the US, has physical presence in the US for at least 5 years. Then the child can acquire citizenship, but certain rules have to be met. So, first, you have to make sure you were born on or after November 14, 1986, that your father was physically present in the US for at least 5 years. Once you have all of that, now you have to meet other requirements that shows that you have been legitimized by your father. Okay, so first you have to show clear and convincing evidence that there is a blood relationship between you and your father. So DNA test, that's basically what that means. They talk they say all of that just to say you would need a DNA test to prove that you are your father's child, right? The father was a US citizen at the time of your birth. That's the second rule. The father agrees in writing to financially support you until you reach the age of 18. And while the child is under 18 years of age, right? So before you, the child, turned 18, your father either legitimized you according to the laws of where you live. So, if, for example, if you live in Nigeria and there's certain rules that fathers have to go through to legitimize their children, your father went through that process. If you live in the United States, depending on the state you're in, if there's certain rules that proves legitimization, then your father went through that process. Or your father acknowledged your paternity in writing under oath, or a court adjudicated the paternity of the child. So either there's a court order, your father swore under oath that he's your father, or whatever rules of law apply where you lived at the time you were under 18, that at that time your father met all those rules, you're good to go. Okay, so if you meet all those requirements, then you will be a US citizen. Okay, but the thing about when the father is the US citizen and you being out of wedlock, there is more for you to prove. Okay, it's not just the physical presence, it's not just that they're a US citizen, but you there's just more that you have to prove in order to show that you are a US citizen. Okay, so just keep that in mind. And then, of course, the rules are the length of time that your father has to be a U.S. citizen, has to be physically present in the U.S. goes up the older you are. So if you were born between 1952 and 1986, 86, then that's going to be different, right? It's going to be 10 years instead of 5 years. I know the laws, you know, sometimes they get better, sometimes they get worse, or harder, but that's just what we have to work with. Hi, Akia. Welcome. Thanks for joining me. So that's, that's what we really have to work within, is what is there. So I wanted to do this live because there's so many people that don't even know, that are walking around the US and could fit all of these things and don't even know it. Okay, that fit all of these requirements and don't know it. They're walking around here thinking they're not US citizens, but they actually are. Do you know how crazy that is? That someone is out there walking around thinking they're not a US citizen, but in reality, they are. So I want to make sure that you're not one of those people. And if you know someone that may fit these requirements, that you are sharing this video with them so that they can see if they fit into it. They can talk to an immigration lawyer and make sure that they're not walking around here US citizens and not know it. Okay? So let's talk about in the when the mother is the US citizen. What are the rules? So basically, the rules are, if the child is born out of wedlock outside of the US, after June 11, 2017, the child gets citizenship if the mother is a US citizen who has been physically present in the US for at least 5 years. That's it. You saw all the rules for the father. That's it. So if you were born after June 11, 2017, and your mother is a US citizen and they have been physically present in the US for at least 5 years, you are automatically a US citizen. Okay? Now, if the child was born between December 24th, 1952 and June 11, 2017, the rules are different. Okay. The child gets citizenship if the mother was a US citizen at the time of the child's birth and physically present in the US for a continuous period of 1 year. 1 year. Okay. So that is, you went from 1 year if you were born between 1952 and 2017 to 5 years if you were born after, you were born 2017 and after. Okay, so the rules did get a little harder, but if you have someone that was born in between 1952 and 2017, they could fit the less strict rule of 1 year physical presence for the mother to give the child citizenship. Okay, so now, if both parents are US citizens and the child was born outside of the US, but they were not married to each other, and the child was born on or after June 12, 2017, the child can get citizenship if the following requirements are met, right? So if it's through the father, you would have to show clear and convincing evidence of a blood relationship, aka a DNA test. The father was a citizen at the time of the child's birth. The father agrees in writing to financially support the child until he reaches 18, and then meet the legitimization requirements. So either a court order, the father swears on the oath that he is the father, or meets the legitimization rules of whatever country the child lives in, and either parent resides in the US. So when we were talking about children born out of wedlock and only one parent is a US citizen, the US citizen parent has to reside in the US. But when both parents are US citizens and you can show that the father meets all the other requirements, then it doesn't matter if the father doesn't meet the physical presence requirement. If the mother meets it, because the mother is also a US citizen, you're good to go. Okay? So that is happens if either one of your parent, right? Either both parents are US citizens or one parent is a US citizen, and you were at the time you were born. So everything I went over is for when you were born, either both of your parents or one of your parent was a US citizen. Now, now, I want to talk to you about what happens if after you were born, your parents got their citizenship. Do you actually get citizenship? Do you acquire citizenship at some point? Well, yes. Okay. Yes, you do. And I'm going to go over how you actually get citizenship after your parents become citizens. So that's actually how I got my citizenship. So I love this topic. So I got my citizenship based on this rule right here that I'm going to go over. Okay. So I love talking about it. I am happy to answer questions. So when you get your citizenship under the Child Citizenship Act of 2000, you get a certificate of citizenship. Okay. So with a certificate of citizenship, it's different from a certificate of naturalization. It will have different names on it, but it serves the same purpose, right? It's just saying that you were not born a citizen, right? So let's go over how this happens. So if you are residing in the US, so basically it applies to you if you were under the age of 18 on February 27, 2001, or you were born after February 27, 2001. Those are the only people this applies to. Either you were under the age of 18 on February 27, 2001, or you were born after February 27, 2001. If you were, 19 on February 27, 2001, unfortunately, this does not apply to you. If you were 18 on February 27, 2001, this does not apply to you either. So let's go over what this looks like, right? What are the requirements and how do you actually apply for it? So, first, you have to meet these requirements. One, the child's parent is a US citizen, right? You just need one parent. You just need one parent to be a US citizen. And you are under the age of 18. You hold lawful permanent resident status. So that means if you are in the United States, you're not here on a visiting visa, you have a green card. Okay. Your parent that's a US citizen filed for you, and now you have your green card. You reside in the United States, and you are in the legal and physical custody of your US citizen parent. Okay. That's the other thing. Actually, that's the major thing here. You have legal, your US citizen parent has a legal and physical custody of you. What does this actually mean? Because, when you come from different countries that do not have this language of legal and physical custody, how do you actually prove this? Right? The US government is looking for court orders um, and all those things. But let's talk about how you can prove this. So, if the child resides with both biological parents, and the parents are married to each other and living together, the legal and physical custody is assumed. So let's say in my situation, when we moved to the US, me, my mom, and my sister, we moved to the US, we live with my dad. So the legal and physical custody is assumed because I lived with both of my biological parents in the same household. So I didn't have to show any court order to prove, right? The court order is to prove that the parent has custody. Now, if the child only resides with the surviving biological parent, or the child was born out of wedlock, um, legitimated, and is currently residing with the parent, that's the U.S. citizen. The child has to reside with a parent who has been awarded primary care, control, and maintenance of the child. So this typically requires a court order. Okay, I know in some countries this is not a thing, but you would have to prove that it's not a thing. So, for example, the ways we've proven this in the past, I've had cases where we had to prove that in Massachusetts, for example, that if the parents are not married, because the law here says if the parents are not married, the mother has full legal and physical custody of the child. And at the time, the mother was trying to get citizenship for her child, and this was an issue. The U.S. Citizenship and Immigration Department did not really understand that she had custody without actually having a court order. So me as a lawyer had to pull the statute, the law that says in Massachusetts, if the mother is not married to the father, she has full legal and physical custody. So therefore, no court order is required. And she was able to get the citizenship because we were able to show that. So if in your country it's a similar thing, or there's not really, both parents are considered to have legal and physical custody, then a qualified lawyer from that country can do the same thing that I did for my client, which is prove that the parent met the physical and legal custody requirements. So it is very, very important to meet that specific requirement, because that can be the difference between you acquiring citizenship and you not acquiring citizenship. Okay. And then if the child, now I was talking about if you live in the US, you have your green card. However, if the child is not in the US, um, can they get citizenship from their parent? The answer to that is also a big fat yes. Okay. But of course, there's requirements that you have to meet before you can actually get the citizenship. Okay. So, for children residing in the US, you'll be filing a Form N600. If you are outside of the US, you'll be filing a Form N600K. Okay, so that there is a difference between the two forms. If you file the wrong one, unfortunately, USCIS might take in your application and then deny it because you don't qualify, and then there goes your money that you put into that application, and you have to basically do it all over again and pay all over again. So we don't want you to waste any money. So make sure if the child is in the US and trying to get citizenship in the US, you're doing the Form N600. And if they are outside of the US, it's the Form N600K. Okay. Now, this has to be filed and approved before before the child can come to the US. All right. The US citizen parent files the N600K on behalf of the child. If the US citizen parent is deceased, then a citizen grandparent or a citizen legal guardian may make the N400K within 5 years of the US citizen parent's death. So it is a little more complex to do this outside of the US, but everything in immigration is a little complicated when you're not in the US. So it should not deter you if you fit into if you meet these requirements. Let's um, let's go ahead and get you that citizenship. Okay, so a child residing outside of the US is eligible to naturalize if he or she meets the following requirements on or after February 27, 2001. Okay, that's the date. February 27, 2001 is the date that you have to meet this requirement on or after that. Okay, so one, the child, at least one of the child's parent is a US citizen. the US citizen parent was physically present in the United States for at least 5 years. Remember, remember, you can file this even if your US citizen parent has passed away, but you still have to prove that they met these requirements. Okay? So just keep that in mind. If the US citizen parent does not meet the physical presence requirement, it can still be met if the US citizen parent's mother or father meet the requirement. So let's say your father is a US citizen, but he doesn't meet the physical presence requirement, but his mother is also a US citizen and meets the requirements, well, then you're fine. Okay. So same thing goes with your mother. If your mother doesn't meet all the requirements for the physical presence, but one of her parents is a US citizen and meets the requirements, you are still fine. Okay. So that's a little loophole there if you fit under any of this. So next, the child has to be under the age of 18. The child is in the legal and physical custody of the US citizen parent. If the US citizen parent is deceased, okay, if the US citizen parent is no longer alive, the child may still qualify if he or she is in the legal and physical custody of the person and that person does not object to the application. So let's say your father passes away and you're living with your mother and you want to file this application. If your mother does not object, right? Your mother has legal and physical custody of you and she does not object to you filing to naturalize under your father, US US government is okay with it. Okay? So, now the next requirement is the child is physically present in the US pursuant to a lawful status. Okay? You have to be in the US at some point in this process in order for you to actually get this. So some people will be able to get a visiting visa just to complete the process, or if their parents file a green card application, or if they are here on a student visa, they will still qualify, but they do have to maintain that legal status. Okay. And finally, the child has to take the oath of allegiance unless it's waived. So if the child is like 3 years old, they're not going to make them do the oath of allegiance. Okay. So unless you fit into these, you can still get your citizenship through your parent while you're living outside of the US. Okay. So remember, if you are in the US, you're filing an N600. Let me rephrase that. If you are living in the US and have your green card, you're filing an N600. If you are outside of the US and you want to file for citizenship through your US citizen parent, you're doing that with an N600K. Okay? So, and you can still do the N600K if you have legal status. Let's say you're here on a student visa and you meet all these requirements, you can still do that. But you have to make sure you're filing the right forms. Again, filing fees are non-refundable. So once USCIS cashes your filing fee, it is non-refundable. So make sure that you're paying attention and you are filing the right the right the right application. Okay. So if you have any questions, put them in the comments. There is so much more to this, but I just want to keep it as simple as I can possibly keep it. But I am happy to answer any of your questions or to do even a deeper dive into some of these requirements because there's so many, and I love talking about this, as you probably already know by now. So, if you want me to do a deep dive into children born in the US, born outside of the US, but are physically in the US, what their options are, I am happy to do a separate whole video on that. So, Feel free to ask me your questions in the comments. If you're watching this on the replay, thank you so much. And go ahead and put your questions, and I will respond to you. And like I said, this video was inspired by a question I received in my comments. So just know, as I always say, sometimes your comments leads to an entire video. So go ahead, ask your questions. That's what I'm here for. I'm literally here every Friday at the same time, 12 p.m. Eastern Standard Time, to answer your questions. So don't be shy. Always go ahead, put your questions, even if it's not about U.S. citizenship, but if it has to be immigration related, of course. But go ahead, put them in the comments, and I am always happy to respond. Okay. Now, that is that's all I have for you today. Okay. If you have any questions about this or anything else, as always, you can book a time to talk to me confidentially about your case. And you can do that by going to my website or by calling my office. My office number is always on the screen. And you can also reach us on WhatsApp on that number. And all my contact information is in the description to this video. So I want to thank you all for your time. And remember, if you like this video, go ahead and hit the like button. If you know someone who needs to hear this, please go ahead and share this video with them. And if you are listening in a place where you can subscribe and you do not want to miss any of my lives or uploads, go ahead and hit the subscribe button. And once again, I am Lilian Chukura. I am the owner of Lily Legal, where we help our clients get immigration status for themselves and for their families using the U.S. immigration law system. Thank you so much for your time, and I will see you next week. Bye for now.